I call the matter of Derrick Grootboom and National Participating Authority others to the hearing.
I am Derrick Grootboom, the applicant in this matter, and I'm appearing in my own stead.
Thank you, Mr. Grootboom.
May it please you, Deputy Chief Justice, Justices, I appear together with my learned friend, Ms. Oswald Ratori, for the respondents.
Thank you, Mr. Soni. Mr. Grootboom.
Honourable Justices, in this matter, there's two condemnation applications on behalf of the respondents bringing these condemnation applications, and then there's the merits of the case. The directions of the Chief Justice to us on the 10th of May is that we should be prepared today to argue on the condemnation applications as well as the merits of this matter. I'm in the hands of this Honourable Court to direct me with which I should start.
I think make your submissions on the condemnations and thereafter on the merits, after which we'll invite Mr. Soni to make his submissions on the condemnation application as well as on the merits. In that way, we won't have disjointed submissions. Is that in order with you?
It's in order, Chief Justice. I'm much obliged to do so. Honourable Justices, the first condemnation application of the respondents was brought on the 13th of March 2013. With regard to this condemnation application, I refer this Honourable Court to the contents of my replying affidavit opposing this application, which points out the flaws in the explanation given by the respondents with reference to this Honourable Court's decision in Etequini Municipality versus Ngonyama Trust, CCT, case number 80 of 2012, delivered on 28 March 2013, at paragraph 28 and 32 thereof, which states the needs for an explanation given must not only be satisfactory, but must cover the entire period of the delay, and that parts of the explanation must not be unexplained. The fatal flaws in the respondent's explanation in this application, in the light of the letter, I humbly argue should cause this Honourable Court to refuse the application for condemnation, the result of which is that on the submissions before this Honourable Court, in terms of its own rules, there is no contest to my Rule 19 application for leave to appeal. However, I would ask this Court to make its own determination with regard to granting the application for condemnation in that application, and I'm therefore in the Court's hands. With regard to the 14 May 2013 condemnation application of the respondents, first, the notice of motion makes reference to Rule 19.4 of this Court's rules. I am of the opinion that the correct rule in terms of which this notice of motion application should have been made with reference to Rule 23B of this Honourable Court's rules. With regard to the affidavits of the respondents in that second application, from the affidavits itself, first, Ms. Colleen Bailey's affidavit in that application, the Honourable Court would notice that Ms. Bailey mainly states in her affidavits that she forgot to diarize the dates, and therefore she was remiss in complying with the directions of this Honourable Court. That, Honourable Justices, I would argue, can never be a satisfactory explanation, especially in the light also of the recent decision in eThekwini Municipality versus Nkonyama Trust.
Particularly if it comes from the National Prosecuting Authority.
Pardon?
I say particularly if it comes from the NPA.
That is so, Deputy Chief Justice, because there are enormous resources that Parliament put into this institution to do its work, and also the State Attorney's Office, and therefore one expects at that level, or as servants of the public, for the State Attorney and the National Director of Public Prosecutions to spend the taxpayers' money well and do their work well.
Well, we'll hear what Mr. Soni says, but in your favour, I say in your favour, we'll hear what Mr. Soni says. In your favour, papers are served on them, they do nothing at all. We issue directions requiring them to do something. Again, they do nothing at all.
That's correct, Deputy Chief Justice. And Deputy Chief Justice and Honourable Justices, you would even notice in the heads of argument that of the respondents that they also admit that with the start of this matter, the disciplinary hearing part of it, they started also with this lateness and not being in time. And this is how the respondents conducted themselves throughout this matter, from the beginning to end. Then, with regard to the supervision of Ms. Luther's affidavit, saying that for her it was wrong of Ms. Davids and counsel Ms. Poshwa Todi to decide that they are not going to file heads of arguments and that they are not going to come and argue in this court. They will rather come here on a sitting brief. She makes the excuse that this came to attention only when she received the 10 May directions of the Chief Justice. Deputy Chief Justice, if this is the manner in which supervision is being done in the civil service, only realizing always at the last minute that something is wrong, not having constant supervision over a matter or something which is in the public's interest, how you conduct your work as a public servant, then there's something wrong. However, and therefore I would argue also with regard to the second condemnation application of the respondents that it is unsatisfactory, and also it does not cover the entire period of the lateness of their application for condemnation. I would then therefore leave the decision of this Honourable Court to grant a condemnation in the Honourable Court's hands. I would now go over to the merits of this matter. First, I would like to deal with this special leave to appeal requirement of the Supreme Court of Appeal. Applicant advanced 3 reasons for why his appeal should have been heard as one satisfying the special leave requirement demanded by the Westinghouse Brake and Equipment Pty Ltd versus Berger Engineering Pty Ltd 986-2 SA 555A. The reasons are: 1. Applicant's prospects of success is prima facie, section 17.5A1 of the PSA, opposite the facts which is in the record of appeal, which is alleged to have switched it on automatically self-evident. It is so self-evident prima facie that a really irrelevant case, such case law or case such as the Masinga versus Minister of Justice KwaZulu-Natal Government 995-3 SA 214 Appellate Division is called upon as acting Judge of Appeal Murphy deals with it in his dissenting judgment on the 16th of May 2013 in the Labour Appeal Court, pronouncing on it in the matter of Solidarity versus Jacobus Adrian Hendrik Kotze versus the Republic Health and Welfare Sectoral Bargaining Council and two others at paragraph 30 of that, 31 of that judgment.
I'm sorry to interrupt you.
Thank you, Justice Jafta.
Because you have limited time, wouldn't it be better for you to focus on the requirements for granting leave to this court rather than the Supreme Court of Appeal, because you are now here? Just focus on the requirements here and go to the merits.
Thank you, Justice Jafta. First, then, with regard to the merits here, I'd like to go to the issue of constitution, whether there's a constitutional issue. A constitutional issue arises under Section 167, subsection 7 of the Constitution in this matter, my heads of arguments, which are with regard to the interpretation of Section 17.5A1 of the Public Service Interpretation Act, because the interpretation that was used by the respondents, that interpretation has an adverse effect on my constitutional right to fair labor practice. I say so because my application actually before this court is an application to review. So what I'm saying, I say, please, honourable justices, have a real look. See whether the jurisdictional facts which the law determines is present here, which would automatically make this specific act to come into operation, and therefore I would be dismissed by operation of the law. My argument is the jurisdictional facts which the section demands is absent, and therefore it's an illegality, it's not complying with the legislation, and this decision of the respondents to invoke that particular legislation, and therefore their action is arbitrary action, which goes to, is an attack on the constitutional principle of rule of law, of which legality is an incident thereof. So I argue therefore that...
Mr. Grootboom, are you saying that jurisdictional fact is absent because you were on suspension at the time?
I'm saying that jurisdictional facts are absent, Justice Zondo. Yes, first, because I was on suspension, which is that I am not allowed to come to work, to be at my workplace and to do official duties, which is the requirements of that particular section. Then furthermore, and I think this is very important, because throughout the arguments of the respondents, they use the term authority of the employer. Now, what is the authority of the employer? I think that is very important for this court to decide. What is the authority of the employer with regard to an employee who is on suspension? My submission is that the authority of the employer while an employee is on suspension is that the employer maintain the right to order that employee at its own will to say, come to work, go to the disciplinary hearing, and so on, or your suspension uplifted, come back. So the employee must make sure that he's always contactable, or she's always contactable, reachable by the employer.
Well, if you are on suspension, your employer has effectively said to you, don't come to work until further notice, or until a certain date, or until a certain event has happened. And is your submission that in those circumstances, you both have an instruction from the employer not to be at work and his permission not to be at work, and therefore the jurisdictional fact required by the section is absent?
That is indeed my submission, and that is also what I advance with regard to the dissenting judgment of acting judge of appeal, Judge Murphy, in the case that I made earlier reference to, because that is basically his argument also. The employee, in this case myself, is not at work because he has been instructed not to be at work. And I make also reference to the National Prosecuting Act, the section which says that any member of the National Prosecuting Authority who is on suspension cannot do his duties. So if I would do my duties or be taken to have been on duty, then it would have been in contravention of that law, of the National Prosecuting Act itself. If that suffices the answer. Thank you, Justice Zondo. With regard to the question of administrative action, I refer in my heads of argument to the case of the National Commissioner of Police.
I'm sorry, Mr. Grootboom. I see that you're proceeding to the next point. Was your suspension ever lifted before the decision or before you were informed that you are deemed to be discharged on the basis of the relevant section?
Justice Jafta, the suspension was never uplifted. From the beginning, that was one of the reasons why I always made sure that I'm contactable by the respondents, because they could anytime uplift the suspension. And then I knew that I need to go back to work. And that suspension was never uplifted. I was never called back to work. Thank you, Justice Jafta. Now, with regard to administrative action, I rely with regard to that the quotation in the National Commissioner of Police versus Senior Superintendent Harry, where Chief Justice Langes then was.
Of course, if you succeed on the absence of jurisdictional facts, then you don't need the argument on administrative action.
That is so.
Is that also your understanding of your own argument? I'm just asking the question to understand the nature of your argument.
That is correct. If the Honourable Court, this Honourable Court decides that the jurisdictional facts were absent, and therefore, Mr. Grootboom, the respondents could not have invoked that section, then that's the end of the matter. But in the event of this Honourable Court deciding that no, you have been dismissed by operation of the law correctly, and now the argument is whether we can review this matter as you made your application that that pager applies here.
No. If pager were to apply in your argument,
yeah,
what would be the nature of the administrative action, and what would be the lapse on the part of the NPA?
My argument,
your full argument, I just want to get it in one or two sentences, very pointedly. What do you say they should have done if this were administrative action?
What they should have done if this were administrative action? My submission would be what they should have acted fairly in that act which they performed. They should have acted fairly. Again, it goes to the constitutional right of just and fair labor practice. So that is what
I find your arguments to be collapsing two things. At one moment, you actually want to rely on a fair labor practice. On the other moment, you want to rely on rights that the Constitution gives you in relation to administrative action. But I just wanted you very quickly to tell me whether you rely on both or you rely on the one, and if it's administrative action only.
I rely primarily on jurisdictional facts are absent, Deputy Chief Justice. A last point is that with regard to the fact that the respondents, whether it's the first or the second respondent, say that I've absconded from work, I would submit that it is a very important requirement to prove the intention of my part to run away from work, never to come back. And that is one thing that I believe is clear, is absent in this case. Throughout, the applicant, myself, always wanted to be a prosecutor and always made sure that he or she can continue to be a public prosecutor. There was never the intention, nowhere in the documentation, that the applicant, through his actions, indicated that he has no intention to work anymore for the respondent. Another point which I do not want to miss is that
when you went to the United Kingdom, what was the status of what was your relationship with your employer then?
At the time of my suspension.
Now, when you went to the United Kingdom,
the status of relationship with my employer was that we were in communication. There were email communications between us.
were you on full salary or not?
I was on full salary at the stage. The full salary was stopped on I left South Africa on the 18th of August 2006, and I received the salary under the suspension on full pay for August, the end of August. The end of September, I received it, and for the end of October, it was from the beginning of October, it was stopped.
You returned on the 30th of July.
Pardon, Deputy Chief Justice?
You returned on the 30th of July.
I returned on the 30th of July. How we get to the 30th of July, how I returned on the 30th of July is that on the 7th of February, I received the letter from the respondents that it's no longer their case that I'm on leave without pay in the United Kingdom. It is now the case that I've absconded, and therefore they are informing me I'm dismissed by operation of the law. So when they changed their mind, I instructed my attorneys, which were Hofmeyr then, to take the matter up for me and to advise me. And then, of course, there are the days in which you need to bring any application if you are not satisfied with the decision of the respondents. And they followed those steps and informed me that I could return soonest. And I did return soonest, asking the university to grant me leave rather to come and write my dissertation in South Africa and not to continue with work in the United Kingdom. So I came back at the earliest.
Before you are invited to make representations, though, in relation to your possible dismissal under Section 17(5)(b), weren't you?
Yes, that was the submission that was made on my behalf by my attorneys at Hofmeyr.
Yeah, but you were invited to make submissions before the decision was made.
That 7th of February 2007 letter reads at the end of it that I have the right to make submissions for the statement, which I did comply with. And therefore, it's also my argument that that decision of the second respondent not to accept my reasons, that decision also is not rational, given the facts of the case.
When you say the second respondent's decision not to reinstate you at that stage, is that because your submission is it's irrational to require somebody who has been told by his employer not to come to work because he's on suspension, to say that person, while on suspension, must ask for the employer's leave to be away?
That is indeed, Justice Zondo, my argument that I'm saying to the Minister, this could not have been done under these circumstances, and therefore I need to be reinstated because it's the wrong application of the law under these circumstances.
Of course, the Minister never gave you her reasons. It was a she at the time, isn't it? You just got information from the NPA, which said these are the reasons why the Minister has made the decision without the Minister actually giving the reasons. Is that true?
That's correct, Justice Zondo. And we took issue with that it is in our papers. We took issue with that, are we dealing with one and the same now, or are we dealing with two separate persons, the NPA and the Minister of Justice? Because now the NPA is giving the reasons that the Minister is supposed to give to us. We raise the issue of delegation. Does the NPA have delegation to answer on behalf of the Minister?
And I didn't see any affidavit by that minister. I don't know if I missed it. Is there any affidavit where she adopts those reasons or confirms that those reasons given by the NPA were her reasons for the decision she made?
There is no affidavit, Justice Zondo. Throughout this matter, and even today, as this matter was prosecuted by the respondents, it was always as if the two are one and the same.
And the NPA, when they gave these reasons, as I understand it, they didn't claim that it's the reasons which the minister conveyed to them. It seemed that it was their analysis of the situation and saying these must be the reasons.
This correct, Justice Zondo. In the record of appeal, it would show that the NPA made a submission to the minister saying, this is why you cannot reinstate Mr. Grootboom. And then the minister just confirmed that, say, I accept this reason that you are giving as the NPA. It was never her reasons.
Mr. Grootboom, do I understand, and correct me if I'm wrong, that an employee, in terms of this relevant section, is granted the right to make representation to the minister in circumstances where the section deeming the employee to have been discharged has been correctly applied? In other words, the representations are made with the purpose of achieving reinstatement of that employee. But where the employee has been told that he has been discharged in circumstances where the section has not been complied with, those representations are not seeking to reinstate because the preceding discharge is not in terms of the relevant provisions. Am I correct or am I wrong?
Justice Jafta, I would submit that indeed Justice Jafta is correct, that if the dismissal is wrong in terms of the first section 17.5a, 1, then the B part of it does not come into play. Thank you.
And if there was no dismissal by operation of law, in terms of those provisions, what is your relationship in law between or with the NPA? In other words, would that mean that you remain an employee of the NPA and have remained an employee of the NPA throughout in law?
In law, my submission would be to that question, Justice Zondo. In law, it means that I remain an employee of the NPA, that I was never dismissed. Thank you. If there's no more questions, then that would be my submissions. Thank you very much. It's an honor to appear before you. Thank you.
Thank you, Mr. Grootboom. Mr. Soni.
Deputy Chief Justice, Justices, I'll start off with the question of condonation. Clearly, the manner in which the matter has been handled since the complaint was brought to this court is highly unsatisfactory. What, though, emerges is that the fault lies not with the client, in other words, not with the respondents, but with the office of their legal representatives. The test...
From when has that been a relevant consideration? Haven't courts over the years said to impute to the party the omissions of the representative?
Yes. No, I do not say, Deputy Chief Justice, that that is a decisive factor. I submit, though, that it is a factor, as has been recognized even from Saluju's case, where the point was made, that there is a point where the conduct of the legal representatives will not shield the litigant from the consequences.
The litigant is the National Prosecuting Authority. It's not Mr. Saluji. It's not some citizen trying to vindicate something. They are charged with administering the law every single day. And the omissions are, I mean, you could start here. We have in this court the Van Wyk case on condonation, and we have the eThekwini case more recently. Have your clients complied with any of those requirements?
The question, though, Justice, is...
No, I've just posed a question. I need an answer.
Oh, sorry, I did say no.
The answer is?
Is no.
Isn't that the end of the matter then? If your answer is the one you gave, isn't it the end of the matter? Please.
Well, Justice Greer, my answer to that is that what this court is faced with is a judgment of the Labour Appeal Court, which would stand unless the judgment is set aside by this court. And we submit it would be in the interest of justice that the submissions of the respondents are taken into account when that decision is being made.
But how can that be, Mr. Soni, if you're not granted condemnation? Your client is not granted condemnation.
The submission I make, Justice Jafta, is that that would be one of the factors which would point to its being in the interest of justice that condemnation is being granted, that condemnation be granted. The cases where this court has closed the door on litigants has generally been where the applicant has not complied. I'm not saying the same principles do not apply, but the fact of the matter is being heard and a decision is being taken. And in the unusual circumstances of this case, we submit that it would be in the interest of justice that the respondents' non-compliance with the directions and the rules be condoned.
Why would it be? There are principles on which we work. And I've just set out the cases to you that set out those principles. How could we thumb suck and say it's the MPA and the Minister of Justice, it's condoned? How could we? You have to give us an explanation in relation to not one but two substantial lapses, non-compliance with rules of the court, as though it were not enough, non-compliance with our directions, nudging your clients to come to court. and we get no joy even out of that. Instead, we get 2 applications for condemnation. How could the state attorney says, I've diarized and forgot about it? How could that, an officer of the court, tell this court that? Directions of the court, you diarize and forget about them?
Deputy Chief Justice, the answer in regard to the non-compliance with the directions is somewhat different from the non-compliance with filing the affidavit. There, clearly the question of when the affidavit should be filed was a factor in the non-diarising. As far as the directions go, the answer is, or the explanation is, that the attorney in the state attorney's office who was handling the matter had, together with counsel at that stage, decided that they would not file written submissions to this court. So although the non-diarising is given as a reason, clearly the main reason for not complying with the direction is that a decision was taken, clearly wrongly, that no written submissions should be filed and that the respondents would abide the decision of this court.
Of course, there comes a time when any court is entitled to disregard submissions where the non-compliance is as egregious as the present one. Why shouldn't we do so here? Particularly if your clients have decided they don't even want to be heard by this court. So why should we even bother? Why shouldn't we just hear Mr. Grootboom and get on with it?
Deputy Chief Justice, that is clearly an option that is available to this court. We would submit that given the fact that the decision was taken by persons who were not aware of the obligations of state institutions when matters are debated in this court or when matters are determined by this court, of their obligation to assist the court in arriving at the correct decision.
An attorney and junior counsel were not aware?
Well, clearly that emerges from the affidavit of the attorney until the head of the office intervened, Chief Justice.
Mr. Soni, would we be at large to take cognizance of the fact that we have had a few such lapses from the office of the state attorney?
So I did hear that.
We've had lapses of not complying with rules from that office.
Justice Squeer, my answer to that is that in each case, whilst it is a particular government office or institution that may be at fault, in this particular case, although the fault is imputed to the government institution, if the government institution itself has not been is not the culprit, we submit that it ought not to be taken into account.
Can I ask you this question, Mr. Soni? The admission by Ms. Bailey that she was remiss, and your admission from the bar that the decision not to file submissions was wrong, why should that be used to the prejudice of Mr. Grootboom? Why should he indicte you? You have no explanation, you admit them.
Yes. Can I say this, Justice Basiela? if this court makes a decision in response to the case made out by Mr. Grootboom, it is not a matter that will be confined to Mr. Grootboom. It would affect every public servant in this country, and it would affect every government department in this country, because if the submissions made by Mr. Grootboom are accepted, it would mean that Section 17.5a is given a particular meaning, and that every government department would now be affected or be saddled with that interpretation. And we submit that whilst it may not redound to the benefit, or it ought not to redound to the benefit of the NPA, the interests of justice require that other government departments and the civil service as a whole not be saddled with a decision that has been taken without any input from government at any level.
But that's precisely my problem. Why would the state attorney not appreciate the importance of this matter? That's precisely my problem.
Again, Justice Bosiello, not to personalize the issue, the remissness of one state attorney ought not to affect such an important issue, which will have an impact on all state attorneys and all government departments.
Well, I think you should nonetheless proceed, and let's hear your submissions. You are alive to our displeasure, and it's quite considerable, particularly when it comes from public institutions. I mean, for instance, if it's so important to have the right interpretation, the principal, the NPA, the agent or representative, the state attorney, should have known all this and should have acted promptly to ensure and to protect those interests, but more importantly, to show some respect to this court. It's very rare where we issue directions and there's nothing coming back, particularly from agencies that administer law, and I mean that administration of justice. So it's a very unhappy state, Mr. Soni.
I cannot but agree, Chief Justice.
Well, let's hear you on the merits, and we will make a decision whether or not you get condonation at all.
As you please. Deputy Chief Justice, Justices, we submit that this matter raises three principal questions. Firstly, does Section 17.5 of the Public Service Act apply to employees who are on precautionary suspension? Two, if it does, were the requirements of Section 17.5a met in the circumstances of this case? And three, has a case been made out for the review and setting aside of the refusal by the second respondent to reinstate the applicant? Clearly,
Mr. Soni, before you deal with these questions on the merits, I assume that your client does not persist with the contention that no constitutional issue is raised in this matter.
No, we couldn't. Can I, before I turn to these issues, make one point, and I make the point purely because it will affect the nature of the decision, whatever the outcome is. In his application to the Labour Court and in his application to this court, the applicant seeks an order reviewing and setting aside the decision taken on the 7th of February. namely the decision, as he puts it, to invoke Section 17.5a. Although it may in substance not have much difference, we submit that the Low case and the Pinetti case are decisive of that issue, in the sense that what would be an issue is, does Section 17.5 apply in this matter? If it doesn't apply, that's the end of the matter. There is nothing to review and nothing to set aside. And so it would be a declaratory order rather than a reviewing and setting aside, unless, of course, one says that Pinetti and Low are wrong. And we submit that those two decisions properly interpret similar provisions in the public service.
Sorry, Mr. Soni. I take it that the submission that you have just made now would therefore be in line with the submission made by the applicant, that if the section did not apply, he remains an employee of the NPA.
Indeed.
Thank you.
The question as to the jurisdictional requirements for similar provisions, and there is no dispute that in substance, for example, Section 14 of the Educators Act, which was an issue in the Pinetti case and this case, that in substance they provide for the same thing. Now, in this case, the Labour Appeal Court, in a unanimous decision, answered the question, does Section 17.5 apply to a person under precautionary suspension? And at page 37, the learned judge who gave the judgment set out why he thought it applied. We submit that those are relevant factors. He gives the following as reasons. He says the employee remained the applicant remained an employee in terms of his contract of employment. He remained subject to the authority of the respondents who were paying his salary. He was obliged to obtain authorization from the first respondent before leaving, and he himself was aware of this. I have no doubt that his engagement with a university in the United Kingdom without permission was irreconcilable with the employment contract with the first respondent.
Well, Mr. Soni, isn't the difficulty with what the learned judge is saying in that passage precisely the question I put to Mr. Grootboom? What does a suspension mean? Is your submission that when you are suspended, you are away from work without your employer's permission?
The submission is, and when one looks at what is intended, in the Masinga case, the then appellate division pointed out the following. It said, the question is, would he be able to resume his duties with the department forthwith if his suspension were to be lifted? And that is the status of a suspended employee.
Yeah, Mr. Soni, but both you and I remember that what was an issue in Masinga, and I have a suspicion that you and I know that case quite well because of previous involvement. What was an issue in that case was the assumption of other employment by Mr. Masinga, which is not what we are dealing with here. But the question isn't the question that is raised by the section, but the jurisdictional fact that Mr. Grootboom is basing his submission on. Whether, as a matter of fact, he was away from work without the employer's permission. And the question I put to him, which I put to you, are you saying that an employee who is on suspension by his employer is away from his employment without the employer's permission?
Justice Zondo, can I, and the tempting answer is to say, no, he has his employer's permission, because that is so. An employee cannot be charged with being absent from duty if he is told to remain away from work. The question...
That's not the only correct answer.
We submit, just Zondo, that the debate has been nicely set out in the solidarity judgment, in the judgment of Mr. Justice Leslai, who gave the judgment in this case, where at paragraph 20 in the solidarity case, he says, an employee who is on suspension must be deemed to be rendering his services and cannot be regarded as being absent without permission for the purposes of Section 17.5.
And assuming that statement to be correct, would that not be the end of the NPA's case here?
Well, the question really then is that what Section 17.5 interpreted properly means?
Yeah, but Mr. Soni, I don't even know whether we need to interpret it properly. We both must agree, in order for the deeming provision relating to discharge, in order for those provisions to kick in, the absence from work must have been without permission. So if your employer has said, don't come to work until further notice or until a certain event, isn't the answer, isn't the position that therefore the employee has the employer's permission and instruction not to be at work, and therefore that jurisdictional fact is absent?
Except, Justice Zondo, that he must, in terms of the Masinga decision, he must still be available to resume his duties if the employer calls him back.
But if he was, well, one here we know that he went overseas with the employer's knowledge.
Yes.
And the applicant has said, and I think he's correct in the terms of the papers, what we have got on the record, that he remained in contact with the employer. So the NPA could at any stage have put him on the spot if it wanted to and said, your suspension is lifted, you must report for duty. Then it would be up to him to make an election. Does he abandon his studies and come back to South Africa to make sure he doesn't lose his job? Or does he continue with his studies and take the risk of his losing the job? And the position is that the NPA never put him to that election.
And that, we submit, must be on the basis that the NPA looked at the regulations or looked at the section as saying that when a person is required to be away from not only work, but from being called to work, he must secure the leave of the employer. And the employee understood his position to be the same. I do not say, Justice Zondo, for one moment, that because the NPA thought that was the position and the employee thought that was the position, that is the interpretation. But the question of whether or not 17.5a applies to an employee who is on precautionary suspension is a question that has wide implications. But not only because of that, but because if one were to take Section 17.5 literally and marry that with a precautionary suspension as happened in this case, and one says, therefore, the requirements of being absent with permission have been fulfilled, one could end up with certain odd results. If an employee who is not on suspension did what the applicant in this case did and went away to the United Kingdom, told his employer, I'm going to study, that employee would fall foul effectively of Section 17.5. And the effect of throwing a veil between employees who are, for all practical purposes, who have no shadow over themselves, as compared to somebody who is facing disciplinary action, would be more favorable. The position of somebody facing disciplinary action and who has been suspended would be more favorable.
But, Mr. Soni, the two cases are not the same. The two cases are different. And the differences are material. The jurisdictional fact you and I have agreed requires that the employee must be absent without permission. Once we accept that if you are suspended, effectively you are under instruction and permission from your employer not to be at work, then the section cannot possibly apply.
Well, we submit, Justice Zondo, that the section must be interpreted having regard to the purpose for which there is such a provision. Admittedly, it's a drastic provision, but it is a provision that applies to all state employees, or similar provisions apply to all state employees. And in interpreting the reach of the section, one needs to ask what is the purpose of such a provision. And the purpose of such a provision, we would submit, is that the employee or that the state remains in control of such an employee, and such an employee may not simply go away in these circumstances without securing the requisite leave.
That's one final question from me. The agreement between the parties, and I don't know whether to call it a settlement agreement, which contemplated that there would be a pre-arbitration hearing. There was an agreement between the parties about that the suspension would continue. Can you just remind me whether the terms of that agreement were that the suspension was to continue pending the outcome of the pre-arbitration hearing, or whether the end of the suspension was linked to anything at all? I have the impression that it was pending the outcome of that pre-arbitration hearing.
Here's at page 41 of the purpose. Parties further agree to have this matter heard de novo. There's nothing said about the status of the parties, of the applicant.
Okay, but it's common cause the suspension was never lifted.
No, the suspension was not.
Thank you.
Mr. Soni, I'm sorry. Looking at section 17.5A1, we're trying to determine the purpose. Would I be correct to say that the purpose served by the section was simply this? Where a state employee disappears from work, doesn't pitch up at the office for a period of more than a month, the employer doesn't know where he or she is, and a month lapses. Then the section comes in to regulate termination of employment between that employee who have disappeared, who's not known where they are, and the state. That is the purpose of the section. But if for some reason the employee shows up after a month, a further subsection grants that employee the right of making representations, which are placed before the minister responsible for the department, and if in the representations the employee shows that circumstances which justify his or her absence from work were present, the minister then would order the reinstatement. So the section was not designed to deal with situations where the employer actually knows where the employee is, where the employer has given the employee the right or permission to stay away from work. Would I be correct to say so?
Just after this, why I said to Justice Zondo that one requires a proper interpretation of Section 17.5. Now, in a case in the SCA dealing with the interpretation of statutes, and that's the Indumeni municipality case, Justice Wallace dealt with the question of interpretation and dealt with how one is to deal with situations that perhaps were not in the contemplation of the parties or of Parliament in the case of statutes in a similar situation. And what one then needs to do, according to that judgment, and we submit that that judgment is quite correct on that score, is to look at the section to see what its reach is. And then, although that might not have been what was intended, the fact that it was not intended does not mean that the section would not apply to a situation that is, for example, before the courts now. And so whilst one accepts that that would be the main purpose, the question that one faces in determining the reach of Section 17.5 is this situation covered by Section 17.5? And we submit it as not a sufficient answer to say, but that was not the original purpose of Section 17.5.
What do you say the purpose is, though? Just to follow up to the question of my brother Jafta, what is your answer?
the purpose is to ensure that employees remain at their duties and comply with their contractual obligations to the employer.
Well, let's come back here, as my brother Zondo put it to you earlier. If a letter said report to duty on within 7 days, and he's sitting in a university in the UK, then he's got the tough election to make, isn't it?
Yes.
Well, he comes back. It would have been a simple matter to do that. If he persists and stays away, then it would be quite a different matter from when he's simply on suspension and he has therefore permission to stay away. So you terminate the permission first, at the very least, isn't it?
Well,
on any understanding of a section. There shouldn't be a way on permission of the employer. Isn't that the core inquiry?
But Justice Merseneke, can I, in answering that, go to a point before? The question...
It might be helpful to answer it directly.
The answer is that yes, but I'm saying it would not be a requirement, because in order to say that the employer could do that, it would require that one makes a decision as to whether Section 17(5) applies to employees who are on precautionary suspension.
Well, we know in its literal meaning you have to be away for a specified period for the jurisdictional fact to be present.
Yes.
And if you're away for that period, but with the knowledge and consent of the employer, and the question arises whether the that one jurisdictional requirement is present, isn't it?
Yes, except, Justice Merseneke, that if one says it doesn't apply to employees on precautionary suspension, then the employer is faced with this difficulty. How does he say to the employee, come back? Because the section, the interpretation...
If the suspension, you say to somebody, come back, the section was never intended to deal with people in cautionary suspension. But you want us to interpret it to extend to that level. It was never meant, I think that's what Jafta was in part putting to you. It was never meant to deal with people whose presence or whereabouts are known, or those who are away with the consent of the employer. Those who are, for instance, known to be ill and away at home, etc., etc. It is meant for a specific purpose. And shouldn't we stick to that purpose? Having determined the purpose, say whether here the jurisdictional facts permit a dismissal.
It is tempting to say that it should be restricted to that. In the Ndumeni case, and if I could just give the citation, it's Natal Joint Municipal Pension Fund, the Ndumeni Municipality, 2012, Volume 4, SA 593 SCA. The following situation arose, that an employee had secured or changed pension funds, and evidence was given that the purpose of the whole scheme was not intended for that, because the employee unduly benefited. And in dealing with the argument that that was not what was intended, this is what Justice Wallace said at paragraph 33. Counsel argued that the proviso should not be interpreted to cover the applicant's case, as it was not contemplated by the draftsman of the provision. But this is precisely the error of construction that flows from saying the process is one of seeking the intention of the legislature and then relying on the subjective contemplation of those responsible for the legislation. If correct, it would have the consequence that once it was demonstrated that a situation was unforeseen at the time the legislation was introduced, that situation could not be brought within the legislation save by amendment, which as a matter of construction would be unnecessary. The fact that something was not contemplated may occasionally be a factor that may affect ascertaining the meaning of the words used. It cannot, however, operate as a bar to the application of a statutory provision to a new or altered circumstance.
Mr. Soni, let's accept that and tell me if I'm unfair, but what you are submitting, as if I understand it correctly, is that for the purposes of interpreting Section 17, one must accept that an employee on suspension must nevertheless ask permission to go on leave during the period of suspension.
That is so.
So if he's suspended for 6 months and he wants to go down to the sea for a couple of weeks, during that time, you say for the purposes of the section, he must get the permission from his employer.
In this case, it would be 4 weeks, yes, if that was the position, yes. And
sorry, Mr. Soni, I'm lost. I thought the section says you absent yourself without permission from work, your place of work, not absenting yourself from where you live. Whilst you are on suspension, you need permission. I thought when we look at the text is clear of Section 17(5). It says, an officer who absents himself or herself from his or her official duties without permission of his or her head of department, office, or institution. So it really cannot refer to my place of residence whilst I'm on suspension.
But what it does refer to, Justice Shafter, my submission is that if you are unable or if you are going to be outside your or unable to perform your official duties if called upon to do so, then you would require the permission of the employer, and if your absence was going to be for more than 4 weeks or 1 calendar month, it would fall within Section 17(5). And we submit that having regard to the principle that the employee must make his services available to the employer at all times, even during the period of his suspension, that must follow. That if he's not going to make his services available, then he needs the employer's permission.
But that principle is located in the contract of employment. And here, aren't we dealing with two different things? It might as well be that when the applicant went to the UK, he breached his contractual obligations. But that's not the case here. The employer has chosen to invoke statutory provisions, and we have to look at the terms of that statutory provision to see whether it applies. The question of whether there would have been a breach of a contractual term is immaterial.
Justice Jafter, my response to that would be along the following lines. When one looks at 17(5), obviously the question of a suspension is not mentioned because that appears not to have been contemplated. But whether or not 17.5 would include an employee on precautionary suspension must be determined in the light of the total context of the employment relationship.
Finally, let's just test that. In terms of Section 17.5, the date from which the discharge takes effect is a specific date.
Yes.
It's a day succeeding the last day of the employee at work. That's what it says. Now, in the case of someone who is on precautionary suspension, what that date will be? How do you work it out?
That date would be the day on which he went to the UK. And the reason is because that's the day on which he could, from that day, for the next at least 30 days, he could not fulfill his official duties if called upon to do so.
No, but the section expressly says the last day of him at work. It says so. Now, should we read that to mean the last day of when he could be available to render services?
We would submit that if it obviously if it doesn't include if the question of a precautionary suspension doesn't fall within 17.5, the question doesn't arise. But to determine if one says it's possible, then the interpretation must be, given the fact that that is what the section requires, then it can only be that's the day on which he could not perform his official duties if called upon to do so.
That's the last question, if I may. I know I promised the previous one was the last one. But Mr. Soni, when an employee is said to be suspended, do you not agree with me that it means his obligation to render services to the employer is suspended? His obligation to perform his duties, his obligation to the employer to perform his duties is suspended. That's what it means, isn't it?
Justice Soni, that is correct. May I, though, read something that was said, and this question arose in the case of Gumede versus Mapumulu Bantu School Board and another, 1961, Volume 4, page 369, Durban and Coast Local Division. Where 1961.
61.
61.
Yes. And volume?
Volume 4, page 639, at page 646, marginal letter B, we're quoting from the decision of Gladstone versus Thornton's Garage, 1929 TPD, page 116. Mr. Justice Hennensberg said, and relying on what was said in the English case of Boston deep sea fishing and Ansel, says, when an employee is suspended, it appears to me that apart from any express instructions, he must hold himself available to perform his duties if called upon, though for the time being he is debarred from doing so.
Now may I ask, what I understood you to address the interpretation on a legal level. On a factual level, what do you rely on the facts of this case to indicate that Mr. Grootboom, the applicant, did not hold himself available?
the fact that he was in the United Kingdom from August to the following July.
Mr. Soni, to fly from England to here, the question of 8 hours or so.
Sorry, I didn't hear that, Justice.
I say to fly from England or London to here is a question of 8 hours.
Well, what emerges is that the applicant had committed himself for a year's study. His application for leave, his communications with the employer indicated that he was going to be there for 8 hours, for a year. More importantly, when his salary was stopped, he didn't come back because he felt that he would make himself available. His salary was stopped before the provisions of Section 17.5 were invoked. All of these were indications that, as far as he was concerned, he was outside the jurisdiction or outside the area where he required his employer's permission to be away from his official duties.
Was the suspension revoked when the salary was stopped?
It was not, Deputy Chief Justice.
But can I ask you this question? On the facts of this matter, is it so that we have no evidence that Mr. Grootboom was requested to come back? At any stage? It's not on the papers.
No, he was not. But having said that, Justice Bosiello, may I make this point, that in his judgment, in the judgment of the LAC, Justice Latsi says that these are not requirements. An employer may, it is not as if on the 29th day there is an obligation on the employer to say, well, the guillotine is going to fall tomorrow. Even if the employer doesn't do that, it's by operation of law. And the only question is not the state of mind of the parties, but whether or not the requirements of the section were complied with. Those were the jurisdictional requirements.
Well, I'm asking you this question on the interpretation that you're trying to ask us to give to the word, that we should have demonstrated that he would have been available if he was called to come back. But how do we know that he would not have come back if there was no instruction given? How do we infer that?
Well, the inference, Justice Bosiello, is to be drawn from the conduct of the parties after the fact of his being in the UK and no leave having been granted to him came to the attention of the employer. The exchange of email shows that that was the state of mind of the employer. The employer initially thought the employee had leave because that, according to the evidence, is what was said when the arbitration was adjourned.
But Mr. Soni, in one of the emails or in one of the letters, particularly page, let me refer to the annexure rather, DG7, it is clear from that document that he was granted unpaid leave on condition that he completed the leave forms. We do know, though, that in the suspension document, he was told that he should not enter the premises of the employer or to have contact with any of the staff of the NPA unless authorized.
Yes.
So how could he have even tried? We do know that he tried to ask for the leave forms to no avail. But we know now that this suspension was never lifted and he was not authorized, as he was told, that he could not enter the premises unless authorized.
Justice Ngabini, there is a dispute on the papers as to the reason he didn't apply for leave. The dispute is at this level. Mr. Engelbrecht, who was the person who had to authorize or recommend the leave, says that the applicant insisted that his leave be on full pay, and he said he would not authorize that. And the applicant then didn't sign the form. Now that's the dispute on the papers, and I can refer you to the passages that deal with it. So we do know that that on the facts was not a bar to the applicants attempting to secure permission.
But do you accept that the chairperson of the disciplinary hearing relied on that information when he postponed the proceedings sine die?
Well, what emerges from the respondent side is that the applicant told the chairperson that he had leave. Now, at the end of the day, he didn't have leave. He was told, if you applied and the leave was unpaid, it would be granted. But he didn't apply for that leave, as a matter of fact. So what was communicated to the chairperson of the disciplinary committee was incorrect. Now, whether that dispute needs to be resolved here, we submit is not decisive. But if it is, then it would have to be on the basis of the Plaskin-Evans case. It would have to be on the version of the respondents.
Thank you, Mr. Soni. The last question from me. On what basis is Penetti on all fours with this case? Is the case not distinguishable from the circumstances of this case?
The Penetti principle is that this is a termination takes place by operation of law without any intruding decision by any official. Once the jurisdictional facts are there, that is what is declared. The law declares that his services have been terminated. The Penetti, that's all that Penetti, that's the extent to which Penetti is applicable in this case. This case, of course, goes beyond that, and it says, would it apply, would that principle apply to an employee who's under precautionary suspension? And we submit that if one looks at the purpose for which such provisions are designed, then it must be on a proper interpretation of Section 17.5.
Well, do you have any further submissions?
Chief Justice, I take it that this would be the only issue, because I did say there were two other issues, but I understand that if this issue is decided in favor of in favor of the applicant, that would be the end of the matter. If it is decided, though, in favor of the respondents, then we submit that the reasons given by the Labour Appeal Court for not reviewing and setting aside the minister's decision for not reinstating the employee would be valid, because all that is done in the representations is to reproduce the argument made in respect of why Section 17.5A is not applicable to his case.
Yes, he persisted in the grounds, but with a somewhat faint tone. Today, you heard that. So
yes.
We'll hear him in reply, but let's hear your submissions briefly. Well, they are in the heads, but let's hear if you have anything else to add.
I'll just look at my notes on that and I'll shorten my statement. I could do no better than refer you, Justice Musineke, to paragraph 40 of the judgment of the Labour Appeal Court, where he says that the reasons advanced are the same, and because I've dismissed them in respect of 17.5a, they cannot hold water in respect of 17.5b. I just add the following, had the applicant in his representations indicated that he'd misinterpreted things, he was under the misapprehension that he didn't need this and so on, and that he thought that would be good cause, then that would be a different issue. All he did was rely on a legality issue, not a reasonable issue, a reasonableness issue.
Thank you, Mr. Soni.
I beg your pardon, Deputy Justice. What are your submissions on costs? Mr. Grootboom asked that your client should pay punitive costs on an attendant client's case. What are your views on that?
The only delinquent conduct, if I could put it that way, and that's putting it at its worst, on the part of the NPA was when it didn't comply with the rules and directions in this court. The applicant has not incurred any costs in respect of attorneys, and so we submit that that cannot be, there cannot be any cost order at that level. Of course, he may be entitled to the costs of his coming to Johannesburg.
All reasonable disbursements.
The reasonable disbursements.
If we uphold his contentions in regard to the interpretation of Section 17.5, why would he not be entitled to the review costs in the Labour Court and all the costs at the subsequent hearing in the SCA, or rather in the application for leave to appear in the SCA and here?
So I understood it in the Labour Appeal Court. I can't recall what happened in the Labour Court, but in the Labour Appeal Court, the applicant appeared on his own. And so to the extent that there may have been legal costs involved, not disbursements, they may apply in the Labour Court.
Very well. Thank you, Mr. Soni. Mr. Grootboom.
Thank you, Deputy Chief Justice.
Were you ever represented by counsel in any of the courts?
Pardon?
Were you ever represented by counsel in any of the courts?
I was represented by counsel in the Labour Court as well as an attorney, instructing attorney.
In the Labour
In the Labour Court. In the Labour Court.
In the Labour Appeal Court?
I represented myself in the Labour Appeal Court.
The Supreme Court of Appeals?
I represented myself, Deputy Chief Justice.
And in this court too?
In this court too.
Thank you. Do you have any?
Very briefly, with regard to the Plascon Evans case, in relation to the completion of the leave forms issue, it's in the papers that on the 17th of August 2006, after the pre-dismissal arbitration hearing was postponed sine die, that I attended to Mr. Wenzel Engelbrecht's office with the representative in the pre-dismissal arbitration hearing, Ms. Boekman, to complete the leave forms. And it is in the papers where I state clearly that Mr. Engelbrecht did not even want to give me a blank leave form. It is never disputed in the papers by the respondents. In a confirmatory affidavit of Ms. Boekman.
How is that relevant anyway to your argument?
No, just in reply to what was advanced now. But,
do you agree there's a dispute there of fact?
I agree there's a dispute of fact.
The narrow point Mr. Soni was making, whatever there is, we have to decide if it's relevant at all. He suggested it's not, but if it is, if we think it is, then it must be decided in favor of the respondents, and that must be correct.
If they dispute, what I'm saying, Deputy Chief Justice, I'm saying they dispute it now in oral argument, but if we go to the papers filed, what I advance, why the leave forms was not completed, in that I was not given it to complete my part because there are 3 parts to the leave form, they never disputed what I advanced, and therefore that evidence, that what I say in my affidavit is the only evidence before this court. There's no dispute then.
Yes, I hear the point. You say he says a dispute of fact, you say there's no dispute of fact.
It's not in the papers. There's no dispute of fact in the papers.
Very well. Any other submissions?
Then, lastly, with regard to my reply is that what I'm gathering from the submission of senior counsel is that the Section 17.5A1 is being argued must become vague. In effect, what the respondents are arguing is that it mustn't be so clear anymore. We must now read other things like suspension into that section. And I want
you were called up to come and resume your duties during the course of your 1-year studies. What would have happened?
Pardon, Deputy Chief?
If you were called up to come and resume your duties during the course of your absence, what would have happened?
Deputy Chief Justice...
I know it's not in the papers, I'm putting it to you, and I want to hear what your response is.
Deputy Chief Justice, the Nelson Mandela Scholarship. Before you leave South Africa, you get a return ticket, and your return ticket must not be for a date later than 6 months. So after 6 months, when you are there, you must renew it. Because the Nelson Mandela Scholarship, throughout its existence, realized that sometimes the need arises for a scholar to return earlier. I was based at the University of Southampton, which had direct flights to Cape Town. I could, if the NPA had asked me to come back, lifted my suspension, I could have been, if there was space available on the flight, in South Africa the next day. And if I could have been in South Africa the next day in Cape Town, I could have driven to Springbok or to Uppington and be there the second day.
See, the point is relevant because Mr. Soni says go and look at the total correspondence and exchanges between you and MPA, and we'll see from there, we'll infer from there that in effect, you in effect were incapable of resuming your duties.
I think I deal also in the papers with it that if they recalled me, I could have come. And really, Deputy Chief Justice, why must we now go and rely on invoke assumptions? Whereas if they did call me back, uplift my substantial factually, then there could have been factual arguments before this court. Why must we go to assumptions if we could have dealt with this matter on the basis of facts at the end of the day? Because it was easy to send me an email to come back. With regard to the email correspondence between me and the respondents, this Honourable Court will read from that email correspondence that my request was just give me the rules or any proof on which, or documentation or anything legal on which you base this decision that you've taken out. And this goes back to, if we go to my papers, back to 2004 when I started work in the Northern Cape, that I took issue with the fact that the respondent, the first respondent, was not conducting its administration of my post in a proper way. There was never instructions in writing on paper. And that was the issues that I took. Even my delegation of power, I pleaded with them that the law requires me to be given delegation to prosecute in different jurisdictions. So I took issue with the respondents from 2004 in how they administered my post. Would it be wrong for me, when they stopped my salary, to ask them, what is the basis on which you are doing this? That is why, and all the emails would indicate that. I just want to lastly refer to the Affordable Medicines Trust and others versus Minister of Health, 2006-3 SA, Constitutional Court, where Justice Noble, as he then was, says that the law must indicate with reasonable certainty to those who are bound by it what is required of them, so that they must regulate their conduct accordingly. What the respondents are arguing, how Section 17 of the PSA must be interpreted, is to create uncertainty and not the reasonable certainty that is required of law. That would be my final submissions and the reply.
Thank you, Mr. Grootboom. As always, in this court, judgment is reserved. The court will rise.